May I go back slightly to this extent, just to show your lordship two documents to back up a submission that I made without reference to documents, just in case it is controversial. The first submission was that the sums came in, as it were, in one stream to forests, and then was divided up like the Nile Delta to the various different exporters. My lord, that is established by the supplementary bundle, tab, I think, 39, page 257. Let me just check that. It's volume 2. Yes. And this is what's known as a wash-up, dating from, there's one for 2014, but dating from largely 2019. And how this works is that, for example, the ADCOM, less costs, is there indicated in red. So red is a credit to the exporters, and demurrage dispatch in the third column. So demurrage is a debit to the exporters, but dispatch is a credit to the exporters. And if we take, for example, the 2018 vessel, the Vidya Nari, well, that's a bad one, because let's take the 2014 vessel, the Denser Leopard. Then the ADCOM is 1.4, and that's per cubic meter jazz. And then there is dispatch going the other way of 4.8. So the estimated total due to the exporters collectively is 3.4 per jazz, per cubic meter. And then it's divided up between OTPP, Tuamata, and Tiaki in that way. So that's it, forests spreading it out. And if, for example, you take a case where there is dispatch, let's take the Ken Ann on the 5/12/2019, which probably is December 2019, then the ADCOM is 71 cents per cubic meter. The dispatch is 3.1 per cubic meter. The total is 1 per cubic meter. That's a bad example because it all goes to Tuamata. That's a case where only Tuamata shipped. But one sees how it works. There are some cases where there's only one shipper, but generally speaking...
So it would have been divided up.
It would have. It is just as an unlucky example, but one can find. And secondly, secondly, the submission, which is supported by this, that at least very often, if not in the majority of cases, there are 3 parcels per ship. So one sees the Denser Leopard, 3 parcels per ship there. The Vidya Nari, only 1 parcel, and that was all Tuamatas. But the Erisort, 3 parcels. The Berge Shari, 2 parcels, one of which must have been very small, and so on. So 2 points. Firstly, the practice was shipping lots of different exporters' cargo on the one ship, and it all came in one lump, as it were, to forests, and forests divided it up, paying what was due for dispatch and ADCOM, and charging what was due in terms of demurrage. And there are separate ones for freight.
Are our ships shown on these tables?
The index is, because that was, it's 23/12/2019, about the 10th one down. The other one, yes. This is things to be washed up in August. So the Cosmos had already been washed up. And there was ADCOM due, and...
Sorry, which line is it?
The 10th, 23/12/19, they go in chronological order. The TS index.
Yes.
And there was 0.05 cents ADCOM and no demurrage or dispatch, so there's 0.05, and then it's divided 3 ways between OTPP, Tuamata, and Tiaki. Yes, the Cosmos is at 278 in a slightly different document, which is for this purpose, may I show you 261 to start with? So this is history, going back to 2009, but it's all material as to the course of dealing, which forms the factual matrix for our transactions. So 261, going back to 2009, one has the wash-ups completed since 2009, and a negative number indicates a credit given to the supplier. And for example, the Glorious Sunrise, that cargo was all Tuamata, but the Beniti Bay, there was a cargo of OTPP, the lines are slightly offset, Tuamata, TBFC, Tiaki, and Viking, 5 parcels there, and one goes through all of this, and one sees generally the practice was multiple parcels, although sometimes a whole ship went with one person. And bearing in mind those headings, if one comes to 278 and into, this is 2019, one sees that there are, generally speaking, only 3 columns, and they correspond to OTPP, Tuamata, and Tiaki, the 3 exporters here. That's not universal, because very small parcels are sometimes, even now, shipped for other people. But the generality, come 2019, is that these are the 3 big exporting clients. And if you see November at 278, the second entry is the Cosmos Harmony. And the total there was minus 18, so there's an $18,000 credit. One sees that in the FAR. Minus 18,965 is a credit to the 3 exporters that my learned friend represents in this hearing. And they were split up 708 to OTPP, 16,000 to Tuamata, and 2,000 to Tiaki. And they are likely, as one sees from the other documents, to be made up from ADCOM and dispatch, but this document doesn't actually show that. So that makes good the submission, both that the habit was to ship many peoples on one ship, and by 2019, generally speaking, but not universally, only these 3. And the other point is that it all went in a one at a forest and then it was spread out. And that's relevant to the issue of several contracts, several charter parties, several liability on letters of indemnity. Now, with that, I come...
That shows there's an awful lot of dispatch being earned.
A dispatch was a biggie.
And since we know that some 550, was it, LOIs
507
were issued, anyway, 500 and something. That suggests, doesn't it, that Mr. LM must be wrong when he says the bills of lading always arrive on time because it's a long journey.
Yes. He's certainly wrong as to that fact. He might be right as to that's what he believed.
Yeah.
Yeah.
Yeah. And it doesn't show that he knew that LOIs were being issued, but
quite.
it does show that he appears to be wrong in
Yes.
his understanding of the speed with which a bill of lading would get to India.
Quite.
Or China.
Because he links the letter of credit to the LOI. So he says, if the LC arrives, no need for an LOI, and there never were any LOIs. So yeah, he's mistaken, at least, and for present purposes, that's all I submit. And but
Sorry, maybe me misunderstanding. If bills of lading did get there in time, in advance of the ship
yep,
arriving,
yep.
why would the earning of dispatch be inconsistent?
Because if the bill of lading arrived, but the letter of credit had not been opened, the exporting seller, or forests on the exporting seller's behalf, would not deliver the cargo against the bill of lading because it hadn't been paid.
No, the bill of lading wouldn't get there unless the letter of credit
Yes.
had been opened. Because
That's true.
It would go through the banking system.
That's true. Yeah. I mean, there might be other copies, but yes, you're right. My lord is right.
I'm still not sure my question is answered. If the bill of lading was in place, so there was no need for an LOI,
Then there'd be
couldn't
immediate...
dispatch still be earned?
Yes, but only then. If the ship discharges straight away on arriving,
Yes.
because BL and LC are already in place, and they have to be both B, then the ship discharges straight away
Yes.
and is released quickly.
Understand. So
Therefore, ship owner pays.
But why does it then mean that Mr. Allen must be wrong?
because Mr. Ellum says that that always happened. But if that always happened, you wouldn't need letters of indemnity. Because letters of indemnity are only if the bill of lading's not there.
I know, but the premise is he doesn't know that letters of indemnity are being issued.
Yeah.
So I'm not sure.
But
I'm not sure it means he's wrong. If he lives in a world where he thinks that the bills of lading have always got there on time, you just don't get to the stage of letters of indemnity.
Quite. And my lord was pointing out that he draws the conclusion that because he didn't know about any letters of indemnity, the bills of lading and the LCs were always in place in good time. And I submit...
Well, he says it's an awfully long way from New Zealand
about 6 weeks.
India, so there's plenty of time for the bills of lading
to go through the Indian banking system.
Go through the system and reach the discharge port.
Yes.
But he appears to be mistaken about that.
Quite. That's my submission. And I think I think the point from my lady's point of view is the conclusion he draws from not knowing about any LCs, which is that the bills of LOIs, which is that the bills of lading and letters of credit were always there in time. That is wrong.
His conclusion is wrong, yes, but
because it's based on a wrong fact.
But it's possible that he had an accurate belief.
Yes.
Well, it's possible that he's stating his belief accurately.
Yes. And that has minor consequences, which I will now make submissions about. But firstly, then move to the law. And the first question is, we say that there was an error of law in the judgment in that if there were ostensible authority as between exporters and shipping, as between forests and shipping, then shipping would have actual authority from exporters, both the charter, but more importantly in this case for the LOI. And that is the Remicon point. And my learned friend says at paragraph 40 that I shouldn't be allowed to argue this because as we accept ostensible authority as an ingredient of actual authority in shipping was not argued below. And he says that at paragraph 40, but he doesn't give any particular reason for that other than the fact that there was no reason why the point could not be taken below. But in my submission, that is not a reason for not allowing the point to be run, which is a pure point of law based on the same evidence that was always in play as to agency or not agency. My learned friend cites the Rhine case, and if I can show your lordship that at Authorities Bundle 3, Volume 3, tab 49, page 1113 of the bundle and page 112 of the All England Law Reports. Lord Justice Popowell, this was, in refusing permission to me to argue a new point after a trial in the Court of Appeal.
Mr. Young below.
I don't make a habit of it, but para 23, page 1113, the applicable principles are not in dispute, and it goes to Singh and Das, and it's put negatively here. These are reasons why you would not allow, but that is against the background context that one should allow a point to determine the real controversy between the parties. So the appellate court will be cautious about a new point that was not raised before the first instance, will not generally permit if ... either it would necessitate new evidence, or had it been run below, it would have resulted in the trial being conducted differently with regard to the evidence at the trial. Third, even where the point might be considered a pure point of law, the appellate court would only allow it to be raised if three criteria are satisfied. A, the other party has adequate time to deal with the point. B, the other party has not acted to its detriment on the faith of the earlier omission. And C, the other party can be adequately protected in costs. Well, my learned friend doesn't say that any of those five inhibitors to a new point is established, and in my submission, they're not, and therefore the point should be permitted. Secondly, as to the point itself, I think I can take this quickly because we've written this at some length, and it's Remicon, and it's Bundle of Authorities, tab, volume 2, tab 31, a decision in the Commercial Court of His Honour Judge Chambers, sitting as a High Court judge. And if I can just summarise the relevant facts here, there's some confusion to be had because various companies changed their names, including changing their names to a company that had its own name otherwise. But in short, the claimant, which was called AJU Remicon, but had previously been called ATC, had an employee, Mr. Lim, who was the general manager and who arguably had ostensible authority. He instructed a broker, Coral, to make a charter party with the shipowner, Alida. So the chain was ATC, Lim, an employee alleged to have ostensible authority, Coral the broker, Alida the shipowner. And if we go to page 563, paragraph 17, the judge says this: a situation which has not been dealt with in the authorities put before me is that in which a person such as Mr. Lim has ostensible authority to bind his principal, and in reliance on that authority, a broker fixes a vessel with a third party who knows nothing of the individual giving the instruction to the broker, i.e. the third party does not know of the ostensible authority, the agent with ostensible authority. It seems to me that where an employee acting within his ostensible authority gives instructions to a broker who makes an agreement with a third party in reliance on that ostensible authority, the broker has actual authority to make the agreement in question. As against the broker, the principal is stopped from denying the employee's authority, with the consequence that the broker acquires actual authority to act. This means that if at the relevant time Mr. Lim no longer had authority to charter vessels in the name of ATC or AFS, but that he retained ostensible authority to, Mr. Kong, who was Coral, relied on that authority in making the charter party, then ATC or AFS becomes a party to the arbitration agreement. In my submission, that's a general point of law, not confined to employees and brokers, because the reasoning there applies to agents and sub-agents equally. There's no magic in being a broker, and there's no magic in being an employee other than insofar as it gives you ostensible authority. And it is not excluded from the undisclosed principle doctrine, because as we'll see in a moment, one element of the undisclosed principle doctrine is that the agent or sub-agent here must have actual authority. But this is an authority on the question of actual authority, and there's no reason why actual authority, when an element of the undisclosed principle test, should be any different. Now, my learned friend says this is obiter. In my submission, it's not, because the judge set out the test there and applied it. The fact that he found there was no ostensible authority does not make it obiter. He said, this is a test and I apply it. That's ratio. The fact that the test is not satisfied doesn't render it obiter. And my learned friend says it's alchemy. But no, it's not. It's law. And it's not just an unsupported decision of a deputy judge, because it is affirmed, or it is set out in Bowstead, and that is in volume 3 of the Authorities Bundle, tab 53 at page 1347, paragraph 5015. I will not read that out. I will just, well, perhaps.
Sorry, which paragraph? 5015?
5015 at 1347 of volume 3 of the Authorities. And there's a red line against it. Some very diligent junior has applied red lines. And apparent authority.
No, that's not extra diligence. That's the requirement
Sorry.
practice in the Court of Appeal.
Yeah, right. Yeah. Just below, in the middle of the paragraph, so also, do you see? So also, a person may be able to rely on apparent authority to be appointed as a sub-agent, e.g. where the sub-agent wishes exercise lien. And this, it seems that where the agent who appoints the sub-agent has only apparent authority to make the appointment, third parties who deal with the sub-agent, whether disclosed or not, need not establish that they knew of the original holding out. The principal is precluded from denying the sub-agent's actual authority to bind, so long as at least there's been no communication otherwise, or nothing to put the sub-agent or third party
Sorry,
on.
I'm so busy looking for the red line, I can't find it now. Where are you?
1347 in tab
I thought you said
53. Sorry, beg your pardon. 1347. and it's in the middle of the paragraph, it seems likely that. And then the footnote 109.
Paragraph 515, is this?
5015, yeah.
Well, I don't have the red line.
Oh.
Even more serious.
It's on the soft copy.
Right.
I do, so that is rather unfortunate.
It is on the soft copy.
Okay.
Yes. Okay.
And footnote 109 is a reference to Remicon and indeed another case, but I haven't brought that one along. And that is at page 1355. One sees what the content of footnote 109. So when apply, so that's legal submission number 1. Legal submission number 2 is that the law of undisclosed principle is...
The other case seems to be a Privy Council case, which, if it upholds it, might be quite important.
It's not very clean, but I'll have another look overnight. But I think it's authority for things further up the page. I don't rely on it,
Okay.
unless Mr. Hain tells me.
Have a look just in case.
Yes, yeah. I have, but
Right.
It was about 3 a.m. Okay, so that's legal proposition number 1. Remicon is good law, and I would add that if my learned friend invites you to overrule it, as he hasn't yet, then that is not a point that ought to be determined on an interlocutory appeal before the facts are established. Proposition 2 is that the law as to undisclosed principle can be taken, I think, from my learned friend's skeleton, para 13, or the judgment of the judge at paragraph 17, which say the same thing. So perhaps I can go to the judgment, which is core 14 at page 17, paragraph 17, page 152. And really, it's paragraphs 1 and 2 from the Privy Council in Sui Yin Huan. I say no controversy here. Subparagraph 1 from Lord Lloyd, an undisclosed principal may be sued on a contract made by an agent on his behalf, acting within the scope of his actual authority. In entering the contract, the agent must intend to act on the principal's behalf. Now that looks like 3 requirements: on his behalf, actual authority, and intend. But in my submission, on his behalf and intend come to the same thing. 2 elements are required. Firstly, actual authority, and secondly, the contract is objectively, I will submit, intended to be not for the agent in his own capacity as bare principal, but as agent for the principal. And in that respect, that the intention is objective, can I, albeit that the agent being objective in a 4-party case means the agent here is shipping, which is sub-agent. The objective appearance must be such as to appear to Forests, because Forests is the agent for all purpose of exporters. And so far as one can reduce this to a 3-person chain, it's Forests, it's my client, shipping, and Forests, because they are authorized to receive information from shipping on behalf of exporters and to give instructions to shipping on behalf of exporters. And that's why I said earlier on, my lord, that the real issue is that link, sub-agency link, because Forests act in all things only as agent for exporters. And so the fact that it's objective in this context, meaning as between shipping and Forests, is clear from a case that my learned friend, I think, relies on, called the Magellan Spirit, and that's in volume 2 of the Authorities, tab 34, and page 638 to 639 of the bundle, paragraphs 16 through to 18 of the judgment of Mr. Justice Leggett, sitting in first instance. And he rejects the submission that what matters is the subjective intent of the agent, i.e. shipping in this case. And one sees that at paragraph 18 on the page 639, so it's the latter half of paragraph 18, the statement of the law makes it clear that if on an objective analysis they consented to the creation of agency, it matters not what the subjective is. So the ratio of this part of his decision is that it's the objective appearance of the principle, the objective intention of the agent as it appears, and in this case to the principle. But of course, in our case, forests have authority to receive communications and to give instructions for the principle. And so if we go back to 18, the question whether an undisclosed, at the beginning of 18, at page 638, the question whether an undisclosed agency relationship was created must depend on principle, not on state of mind of the supposed agent at the time of contracting, but on whether the supposed agent had communicated to the supposed principal an intention to contract on its behalf. Now, that doesn't have to be on the particular agent of contracting. The supposed agent can signify intention by signing an agreement that says, I act for and on behalf of the exporters. So it can be anterior consent, and it can be consent, so communication at the time, and in my submission, in a minute, both are present here. First, because the 2012 agreement is a sub-agency agreement, signifying that shipping will act for and on behalf of the third parties. And that is communicated to forests, who have authority to receive that communication for exporters, as they generally have actual authority in that case. And secondly, when shipping asks for authority or instructions to issue the LOI, they ask forests as agent for exporters, because forests are always agents for exporters. And when forest says, I instruct you, yes, issue the LOI, that is an instruction on behalf of exporters, because it's always exporters. And so that exchange is itself the request and the instructions, communication of the intent to act for forests, but forest means exporters, because they always mean exporters. So communication is not an issue. And then finally, the law of apparent authority. Well, I don't think I need very much on this. Perhaps I can just show you the formulation Bowstead at paragraph 1011, authorities 3, tab 53, page 1298. We're not into the minutiae, in my submission anyway, of the law of apparent authority, and so therefore 1298 we can simply take the general proposition known, I'm sure, to all in this room. By further extension, the law may treat a third party dealing with a person who appears to have authority from the principal as entitled, by virtue of the principal's manifestations to that party by words or conduct, to assume that the person in question has such authority, regardless of anything that occurred from which the law would draw the conclusion that if the matter were an issue only between the agent and the principal, and I needn't read that out, but apparent authority or ostensible authority is widely known. Something must come from the principal. And in this case, because ostensible authority is relevant only to the leg between shipping and forests, the question is, does forests have ostensible authority? So the question is, have the exporters held forests out as having authority? And I submit on the facts, obviously, the answer is obviously yes. You can reliably take a view in my favor of that, but at the very least you can't reliably take a view against me. The facts are these. As we see, the exporters appointed forests as a general agent with wide authority, subject only to some limitations, but private limitations in that contract. The exporters gave the logs unto the control of forests to sell them and export them. So far as people like shipping are concerned, forests are there with control of the logs, both to sell, not relevant here, but also to ship. Thirdly, it is evident that the exporters left everything to forests. And for that purpose, you've already seen that it seems Mr. Ellam had no idea what was happening about letters of indemnity. But it goes further than that. If I can ask you to look at the second part of the supplementary bundle at 67, tab 67, paragraph 24 of Mr. Ellam, which I showed you very briefly. But I'm now making a specific point. So 440, volume 2, tab 67, page 440, paragraph 24. Forests would be paid on a per volume basis for the service and would take its commission once payment was received for the logs. Manulife, and that for this purpose is exporters, would then remit the balance to the relevant forestry entities. Pursuant to the management agreements, title remained with the forestry entities until the sale had been completed. The forestry entities did not have visibility over the end customers for their logs or to whom they were unloaded. And that characterizes it. The forestry entities didn't have visibility, didn't know. Everything was put in the hand of forestry. They didn't even know who the buyers were and who the receivers were. They just passed the whole business over to forests. And that is ostensible authority in forests to shipping to deal with all matters up to and including the point of delivery, including letters of indemnity. And the private limitation to a particular regime in the letters of indemnity on which the judge relied doesn't detract from that ostensible authority. And I would say further, the exporters knew that there was an agreement between shipping and forests, but they didn't see it. But in those circumstances, they have permitted forests to make what I characterize as an agency agreement and represent in that agreement, firstly, well, warrant in that agreement that everything they do is authorized by exporters, but also to represent in that agreement that everything they do is authorized by exporters. So I submit you can reliably take a view that there was ostensible authority, and you can also take a view that it was relied on because shipping actually asked forests as agents for exporters for authority to issue the letters of indemnity. Strong case we're right. At the very least, one can't reliably decide the point against me on the present information. And so, as a result, because of the reasoning flaw, the absence of actual authority in the first stage means no authority at the end, we submit that this appeal should be allowed on that basis. Finally, there's the intention or the express or implied agency on the facts. And my learned friend deals with this at paragraphs 47 to 60. In my submission, you can reliably decide in my favour that, objectively speaking, what shipping did was express the intent and to make its contract in the charters and the LOI in particular on behalf of exporters, not its own name as a bare principle. And my learned friend characterized this as a question of implied agency, but I submit not. I submit it is express agency. In the contract, which I say is the contract of sub-agency, the services in paragraph 5.1 are to provide services on behalf of the export clients. And forests, on behalf of the export clients, say, please provide this service, issue an LOI. And that is express. Sorry?
Shipping say, or forests?
Forests say. Forests say to shipping, please issue an LOI. Amrose said to shipping, please we'll issue you an LOI. But Forrest said to shipping, please
issue... On the AOK, shipping's request for authority to do it.
Yes, yes. So that briefly, so I submit that the request and the instruction For example, let's take it in the supplementary bundle, tab 1, page 214. Miss Guo of Shipping says to Mr. Essen of Forests, please approve the following LOI. Andrew Essen says okayed, and the equivalent for the index is, and that went through a few iterations, can wait till Monday and so on, but perhaps 225 is, maybe I took this too quickly, but 225 is the 9th of December, and that's the instruction that actually led to the letter of indemnity. So perhaps I should have shown you that one at 31. So on the 9th, Becky Guo of Shipping asks inter alia Smith and Essen of Forests, we need to issue the LOI today, and Essen says, Becky, okay to go ahead, but please run the LOI past Jason before sending out also thanks. And there's some correspondence along those lines. And similarly, 247 for the TS index, the same pattern. At the bottom of 247, at 248, Becky Guo says need to issue an LOI. 2/3 of the way down 248, and the end point at 247 at the top is Becky, okay to go ahead with LOI, but please wait, just in case, I paraphrase, just in case we don't need to. And against the context of clause 5.1, which is a promise by Shipping to Forests to perform services on behalf of exporters, that is express agency. If not, in the context of the factual matrix, it is necessarily implied agency. And in support of that, I have, I think, 6 brief submissions. This is an alternative implication. The first goes back to the position before shipping were introduced. Before shipping were introduced, Forests chartered ships as agent for the exporters. Shipping were then introduced, in the words of the letter, as part of the service provided by Forests. See page 177. So the clear conclusion is that this new TPT company was acting in the same capacity as Forests had previously, and there was no major change of capacity such that the TPT group, having previously acted as agents only, suddenly were taking liability as principal without a back-to-back indemnity, or without an indemnity from the exporters, and indeed without back-to-back charter parties or LOIs. They were not going naked, as it were. Secondly, the ring fencing point. Now, this is capable of 2 interpretations. If it's to ring fence the exporters, then the point doesn't assist me. But in my submission, as between shipping and Forests, which is what matters, it's clear to insulate Forests. And that therefore shows that if to insulate Forests and the wider group generally, there has to be an agency through to exporters. Of course, there is a liability as agent for an undisclosed principal. There always was, but at least there's one further level of insulation, that Forests can be used as a sacrificial anode. My third submission might come under the heading of cui bono, as the jurist Cassius Longius Ravella said. Who benefits? The answer is the only person that benefits from the LOIs is exporters. And the judge deployed this factor significantly in deciding that forests weren't the charterers or the LOI principle, but that factor points necessarily in favour of exporters, because otherwise my learned friend would have you think that that shipping were undertaking huge personal liability with no comeback down the line for no remuneration. And that is absurd.
Why could it not be that they would, let's say shipping would issue the LOI on the basis that if called upon, they would expect to be reimbursed by exporters, just as the freight and the demurrage and the dispatch all went to exporters' account, but were not on the basis that they were contracting so as to make exporters a principal to the contract with the ship owners.
Well, then my lord would have to infer, I was about to say invent, but that would have been unworthy of me. One would have to infer a contract of indemnity separately, or a back-to-back LOI. And that none of that is suggested by my learned friend. Why go to the trouble of inferring a separate contract of indemnity where there is a much more obvious and necessary analysis of what happened, particularly in view of the terms of what I call the sub-agency agreement and the requests, which is agency? And my learned friend characterizes as implication, but in my submission it isn't really, it's factual matrix for construing what was done in 2019 under the 2012 agency agreement. But my lord is right. In the particular question, my lord said, what is wrong with that? Well, there's nothing wrong with it in that one could have a contract that says, I as principal but not as agent will do this for you. You will indemnify me. Not as principal, but as a principal indemnor, and I'm a principal indemnee. Yeah, you could write that, but is that the correct interpretation of what happened under the 2012 agreement when shipping says to forests, we need an LOI, please approve, and forests says back, always on behalf of exporters, yes, issue the LOI. In my submission, agency is the only realistic interpretation of that as such, although you could craft a contract which did not involve agency. You'd have to write out an indemnity, you'd have to write out its terms, whereas agency comes with a prepackaged, as it were, indemnity as part of the law of agency. So that's my submission. Not impossible, is the answer to your question, but not the right interpretation. The next is commercial suicide. As we've seen, shipping earned nothing on these actual charter parties. Now, it may be, and there is evidence, that if a little bit of space was left over after the exporter's needs had been served, then shipping were at liberty to fill it up and make some money that way. It can't have been very often, because we've seen from the documents that the usual position in the later days was just these three shippers. It may have happened in this case, but that is consistent with agency as well as with principality. There's nothing wrong with an agent for an undisclosed principal devoting himself to his principal, but once the principal has used up all his logs and there's a bit of space on the ship, the agent is allowed to make a profit for himself. And indeed, the evidence is that this was a known way of working, so therefore it wasn't an unauthorized secret profit. So subject to that possibility, it was commercial suicide for shipping to do this without either an inferred sub silentio from conduct contract of indemnity between indemnor and indemnee, or, I would say, the only realistic analysis is the indemnity of an agent. And again, at risk of becoming boring, my submission is, can you reliably take a view against me on this in circumstances where the circumstances in which the LOIs were actually issued as a matter of practice in 2019 are curious, given the evidence of Mr. Easton and the 507 point. And finally, I think this is the fifth point, but it's dispatch and address commission in the Charter. Now, this goes to the charters, not directly to the letters of indemnity, whereas all my previous points have gone to the letter of indemnity as well as the charters, but mainly the letter of indemnity. But the point is, I do say that the transferring of all the remuneration qua charterer under the charter parties by way of adcom and dispatch to the exporters is consistent only with agency. Now, no doubt one could create a contract which says, your principal, you're going to do this as principal for me, but any remuneration you receive doing that as principal, you will pass over to me. But that is a far less, one only infers contracts, one only creates implied contracts if that is the only explanation. And it's not the only explanation, because the obvious explanation is agency. Indeed, my lord, I think that might be said about your lordship's put to me earlier, which is you could infer an implied contract of indemnification in the principal-to-principal situation. But the law on inferred or implied contracts is that has to be the only explanation for what has happened. And it isn't. Agency is another explanation. I do remember the Aramis, I think. To imply a contract of anything, but to imply a contract of indemnity, let alone to imply a contract that I will pass you all the profits I make on this charter, that has to be the only explanation. It isn't. Agency explains everything.
I think it's used in that context, if I recall correctly, as to whether there's a contract at all.
Yes.
Whereas to an extent you're postulating different forms of contract.
I'm not, because what was put to me was that to answer the commercial suicide point, there could be a contract between shipping and exporters of indemnity. That's creating a contract. And equally, there could be a contract between shipping and exporters that shipping shall give all the earnings under the charter party. That would be a created contract because it's not in writing anywhere. It would have to be inferred or implied. And it's not necessary to do so because there's an obvious explanation, agency. And that's my submission.
Well, I mean, you say, don't you, that it makes absolutely no sense for shipping to incur this liability under the LOIs without having a right of recourse of some sort against somebody. That somebody could only be exporters because there is nobody else.
And because forests say agent only.
Yes, and there are two routes by which that might have happened, one being agency, one being some sort of indemnity contract. Is that basically your
That's exactly
side point?
Except I go on to say, because of the dispatch and adcom, it would have to be not just an indemnity, but a transfer of benefits contract. Yes. And it would have to be a sub silentio contract. Why go there when we have a contract between shipping and forests, which says that I will provide services, but I'll provide them to the clients, the export clients, or for and on behalf of the export clients?
Well, the third possibility is that shipping thought they had a right of indemnity against exporters, but forests didn't in fact have authority to give that, and therefore it's a breach of warranty of authority claim, which I think is what Mr. Bailey said.
He does, and the answer to that is that if the objective appearance between shipping and forests is that forests had ostensible authority to do that, though they did not have actual, then shipping had actual authority to contract with my client, and that is the Remicon point.
So your case does ultimately depend depend on the Remicon?
It does, yes, it does. But every other element of it is, in my submission, not just good arguable, but if you can take a reliable view either way, we must be right on this. But subject to Remicon, yes.
Yes. As a basic proposition, an undisclosed principal is liable only if they give natural authority to the agent. That's the starting point. Remicon was not a case of an undisclosed principal.
No.
Is there any authority which sort of bridges that divide?
No.
Right.
And my submission on that is twofold, my lord. Firstly, Remicon, that is a factual difference between Remicon and this, which doesn't affect the principle, because what Remicon is about is when is there actual authority. And actual authority is one element of the undisclosed principle doctrine, as we've seen from the pre-council case. And as I think I said earlier on, there's no reason why actual authority, when deployed in the undisclosed principle arena, should mean anything different from actual authority elsewhere in the law of agency. In other words, the difference between undisclosed principle and disclosed principle is not material for the application of Remicon. And the second thing I would say is that if one was to say, well, Remicon is to be confined to disclosed agencies, that's what I might call a Supreme Court point, and not one to be decided on well-known authority at an interlocutory hearing like this until the facts are known, not least because it might be a Donoghue and Stevenson case, which, as it went back, it was found there was no snail in the ginger beer bottle. So it's just not convenient to do it that way. But my main point, my lord, is that there's absolutely no reason to distinguish the undisclosed principle case from the disclosed principle case, because the bit of the law we're concerned with here is actual authority. Yeah. Now, very briefly, because I think I've used up all my time, so to save myself 5 minutes from reply, can I just briefly respond to my learned friend's written submissions, Respondents' skeleton argument, as to why, supplementary reasons why he says there's no agency here, which I take as meaning no objective intention. And it's at pages 103 of the core bundle. No implied agency arrangement, he says. And my first submission is that we rely on express agency construed in context in the factual matrix. We are not saying primarily implied agency. That's only an alternative. Corporate structure. This point, we're not relying simply on the corporate structure. And insofar as he makes in paragraph 49 the ring fencing point, then our submission is that the ring fencing was ring fencing of forests and not ring fencing of clients, at least as between the parties where it matters, forests and exporters. 51.2 is no consent to agency relationship. In my submission, there was. The clients permitted and were notified and permitted forests to use shipping, and they can't complain if the way it was used was agency. And there was consent conveyed by forests on behalf of exporters. So it's consent. The point here is that when exporters permit forests to act, and forests are always acting on behalf of exporters, and there was at least ostensible consent by forests on behalf of exporters. But I submit actual, because exporters allowed forests into that position. 3, spare space, that's at page 106. I submit, so what? That's consistent with agency. For the LOI chain, I say the important thing here is that there was no LOI to shipping. And so up the line, sorry, there's no up the line LOI to shipping. There was one from Ambrose, and that is the commercial suicide point, because Ambrose is a Singapore company acting for internal Indian receivers. So, but that's the point here is there's an Ambrose LOI. My point is that there's nothing in favour of shipping from exporters. The position of shipping's administrators and liquidators is irrelevant. It depends on who's funding them and what for, and that's got nothing to do with it. And no control. Now, this I want to just say as the last point. Nowhere has Berge suggested the exporter dictated or could dictate how shipping carried out its work. Yes, it could, because forests acts for shipping in this context, and forests dictated LOI or no LOI. So control through the agency of exporters, of forests, is a significant indicator, which I rely on. So well, I think subject to questions, those are my submission on that one.
Well, thank you very much, Mr. Bailey. Mr. Bailey.
My Lords, my Lady, may it please the Court. Gosh, I seem to have a bouncy. What I'd like to do, if I may, my Lord, is start with some brief submissions on the proper approach to this appeal. And in particular, just to reiterate what the test is in relation to jurisdiction. And the reason I do that is because various times during my own friend's submissions, this may be forensic rather than analytical, he said, you can't reliably determine that point against me. I just wanted to reiterate what the relevant test is. And that is that my own friends have to show, for the purpose of the relevant gateway, that they have a good arguable case that my clients are party to an agreement with a jurisdiction clause. And that requires them to show that they have the better argument. And if my clients, as they were able to persuade the learned judge, can show that they have the better argument, I don't have to prove a summary judgment test against my little friend. I just have to show that I have the better argument, that that shipping contracted as principal and issued the LOI as principal. And if that's the case, my little friends are not able to discharge their burden, which rests upon them, to establish a good arguable case that we're bound by the jurisdiction clause. So that's the nature of the test being considered. The second point in this context is that I do accept, and therefore it's common ground, that the conclusion that the judge reached, that my own friends did not have a good arguable case, is an evaluative one. And what that means, my Lord, in my submission, is that this court should be slow to interfere with it. And it should only conduct a fresh evaluation of its own if it's satisfied that the reasoning of the judge or his evaluation of the evidence was flawed. It contained an identifiable flaw. Now, I'm sure this is relatively straightforward. Don't actually believe it to be controversial, and I'm sure it's fairly familiar territory to the court. And I don't want to take up time by labouring it, but I would, if I may, just like to turn up two brief passages just to make points which are relevant given when my own friend put his case. The first is the CAFA decision of this court in 2019. It's in Authorities Bundle 2, tab 42. And this is a particularly relevant case to look at in this context because it was an appeal involving a jurisdictional dispute from a decision of the High Court. where the judge had held that the claimants had failed to establish a good arguable case that the defendants were party to a jurisdiction agreement as an undisclosed principle. So it's in exactly the same territory we're dealing with here. And the Court of Appeal in CAFA characterised that conclusion as being an evaluative one with which the appellate court should be slow to interfere. And the two passages I wanted to show you, the first is from Lord Justice Green's judgment at page 836. Paragraph 95. The court's got to be exercise reticence in second-guessing the exercise undertaken by the judge. It's worth saying it's not open to an appellant to invite the court to re-perform the analysis of the evidence to see whether it agrees with the judge. So it's although the court, if it satisfied that the learned judge below did make an identifiable flaw, this court then comes to consider the matter afresh. I understand that, but you can't simply re-argue it, as sometimes it may have appeared from my own friend's submissions, de novo. And that comes out, I think, more clearly from Lord Justice Davis's judgment in the same case, tab 42. And the other passage I wanted to show you is at paragraph 123, page 844. In the ordinary way, the appellate court in a case of this kind will not interfere with the judge's decision on such an issue unless there has been a material error in the legal approach adopted, failure to take into account material facts, taking into account immaterial facts, a demonstrable misunderstanding, an evaluation that's so unreasonable as to transcend the ordinary margin of appreciation available to a first instance judge. So that's some guidance, my lord, to the proper approach, and it's reiterated. I mean, slightly two additional points to make, but it's reiterated in a case called In Re Sprint Room, which is in the same bundle, 2 tabs on at tab 44. And there are a couple of points in this judgment, which is the judgment of the court itself, consisting of Lord Justices Macomb, Leggett, and Lady Justice Rose. And the passages I have in mind are run from paragraph 72 on page 874. You can see at 874, paragraph 72, the question of the room for appellate challenge of such an evaluative decision as an area of our procedural law attracted much attention. And then actually there's quite a long, I'm not going to read, certainly not going to read it all, but basically the passage explaining the approach of the Court of Appeal goes from paragraph 72 through to paragraph 81. But what I would like to do is pick up just two or three highlights which are likely to be of assistance. Paragraph 76 on page 877 is the key statement, and it's set out, I think, in my own friend's skeleton. So that's where you find references to a gap in logic, failure to take account of material factor. So that's the basic test. What I wanted, 2 points I wanted to get out of this too, which in my submission are helpful, is actually what Lord Hoffman says, paragraph 77, where he refers to the quotation from Renan, the French historian, that the truth is in the nuance, in the context of saying that the judge's expressed findings are always surrounded by a penumbra of impression as to emphasis, relative weight, minor qualification and nuance, which time and language do not permit exact expression, which may play an important part in the judge's overall evaluation. That's true, even the most meticulous judge. And the other point I wanted to emphasise that comes out of Lord Justice Lewison's judgment, which is referred to paragraph 78, is the fact that, as inevitably is the case, the court below has a vast greater volume of evidence than is before an appellate court, particularly this one. And just to illustrate that fact, in this case, before the learned judge below, there were 10 volumes of documentary evidence, extending to some 3,750 pages. Now, we have a supplemental bundle in this case, and Master Michu was generous enough to allow us to have, I think, go over the 350-page limit, but only by, I think, 200 odd pages. So we have a total of 500, I think, 591 pages of the supplemental bundle. Obviously, we've sought to identify the key materials, but what Lord Justice Lewison's point is you need to remember that compared with the exercise and the task the judge undertook, what we're doing is effectively taking a snapshot, or as Lord Justice Lewison put it, we're involved in a process of island hopping, looking at individual pieces of evidence rather than seeing it as a whole. And all that is relevant when you come to consider and assess whether the criticisms that my learned friend makes of the judgment of the judge below, in terms of his evaluation of the evidence, are valid and fair. And in that regard, when you come to consider those criticisms, and in particular the interplay between the paragraphs dealing with Forrest's case and the paragraphs dealing with my client's case, it is important, in my respectful submission, if only out of fairness to the judge below, that you bear in mind the nature of the case with which he was dealing before him. And what I mean by that is that my learned friend's clients before the learned judge were contending that both Forrests and or the exporters and or at least one of them and or a combination of them, in fact anybody who was solvent, were undisclosed principals to the charter parties and to the LOIs. And it was a scattergun approach in relation to agency, and they didn't even run the AJU point, which my learned friend now accepts is an essential part of his case on this appeal. And now, what that means, my lord, is that given the context and the nature of the case the learned judge was dealing with, in my submission, what the judge did was bring a structure and a level of clarity to the analysis against the background of a somewhat confusing and, in certain respects, incoherent argument that was then being advanced by the owners. And I make all those points because inevitably there are imperfections to be found after the event. But in fairness to the judge, it's important to bear in mind the context within which a judgment and evaluation took place. Now, against that background, and obviously I will develop more detailed submissions in due course, what I would like to do is make my headline submissions and then explain to you where I'm going to go. I've got three headline submissions to make to the court. The first is this, and this is my primary submission, that there were no or are no material flaws in the judge's evaluation of the evidence and no proper basis on which to disturb his conclusions. So I'll develop that. Secondly, even if, and this is my first alternative submission, even if I'm wrong on that and you're against me and you were to undertake an evaluation of the evidence afresh, then for the reasons I will endeavour to explain, it should still lead to the conclusion that my clients have the better argument, which is the test I must satisfy. My clients have the better argument that shipping contracted as charterers and issued the LOIs as principals rather than as agents or sub-agents for my clients as so-called undisclosed principals. So our first alternative submission is that shipping contracted as principals and issued the LOIs as principals. Now, my second alternative submission, and this is where the AJU comes in, is that even if I'm wrong on that, and you were satisfied that the owners do have a good arguable case that shipping purported to issue the LOIs as agents, in other words, you're satisfied that shipping was acting in an agency capacity or purporting to do so. The better argument, in my respectful submission, is that shipping had no actual authority to issue the LOIs as agents or sub-agents for my clients as undisclosed principals. And that's a reflection of what the learned judge described as his second one. My friend describes as the second ratio, his hypothetical point to the effect that even if he was wrong in his primary reason, which was that shipping were acting as principals, even if he was wrong about that, and there was a purported exercise of an agency role, then shipping had no actual authority, because forests had no authority and couldn't confer greater authority on shipping than they had for themselves. And that's the area of the argument where the AJU case comes in two ways. One is whether they should be permitted to run the point at all at this stage, and secondly, if they are, whether it's right or even arguable, which in my submission, for reasons I'll seek to explain probably tomorrow, it's not. So that's the outline of the structure of my case. Those are the three submissions. And what I propose to do, if I may, and this perhaps gives you a kind of roadmap to my submissions, and it identifies the questions which we say fall for determination by this court on the appeal as follows. Round one, as you recall, is the question about who's the party to the Charter Party. Are shipping who contract on the face of it as principals, in fact acting as agents for my clients as undisclosed principals? And the question ground one gives rise to is this: was the judge right to conclude that the better argument is that shipping chartered the vessels as principals rather than as agents for the exporters as undisclosed principals? That's, we would submit, the proper question that arises. And we submit, as I will develop in due course, that the answer is yes. And there are 5 topics that come under this heading, or that are relevant to this question, and they are the contractual scheme. And we submit ultimately, once the contractual scheme is properly understood, that in fact provides the complete answer to the case, really. But I'll seek to make that submission good. But the contractual scheme is the starting point, and ultimately points the way home. But in addition to that, the other factors and topics are the significance, the timing of the charter parties. Secondly, the significance. Thirdly, the significance of the flow of funds. Fourthly, the significance of shipping generating a profit for its own by selling space on the vessels to third parties. And then finally, the significance, if any, of the financial statements of shipping for 2019 that were prepared by KPMG. So those are the topics I'm going to consider under ground one. And then we get to ground two. Now this is the ground that really matters, in the sense that it concerns the true question, namely who was party, who was contracting as principal to the LOIs. And in my submission, ground two in fact gives rise to 2 separate inquiries. And the first is this: was the judge right to conclude that the better argument was that shipping issued the LOIs as principals rather than as agents, and therefore the issue as to the scope of shipping's actual authority simply did not arise? And that, of course, is our first answer to the AJU point, is that it simply doesn't arise in any event. And the reason it doesn't arise is because at all material times, shipping was acting as a principal. And therefore no question as to the scope of its authority arises.
Was it acting as a principal with any right of recourse against anybody if called upon to pay on the LOIs?
Yes, Ambrose.
Only Ambrose.
Only Ambrose. Certainly, it had no right of recourse against either forests or against my clients. And in fact, for reasons I'm going to try and explain, that was the very purpose of shipping's creation in the first place. The ring fencing, the fence that circled the ring, was a fence that went solely around shipping. Shipping was, in a sense, designed for the purpose of this business as a form of sacrificial lamb. It was carrying the risk of the LOI, it was carrying the risk of damage to the vessel, carrying all the risks inherent in chartering vessels. that was the product that TPT was selling to my clients. My clients are the forestry people. They deal with logs. Obviously they want to sell them, but they don't want to be in the business of chartering vessels. And the business and the product which TPT sold to my clients involved a structure whereby when shipping was introduced, as we'll see in a moment, that was a benefit, not just for TPT, because it purportedly insulated TPT from the risks, but it also benefited my clients by insulating them too. And that is obvious, because if there was recourse against my clients by shipping, it's highly likely that my clients would then have recourse against forests, who, as their agents, were likely to be liable for what occurred. So the only safe way of both let me make it, I'll try and explain what I mean by that when I get to the point. I'm sorry introducing it, but I take your hesitation on board, and I will therefore concentrate on it. But what I'm saying is the safest way to insulate both forests and certainly my clients, and to create this fence within which the risk is contained, is for shipping to act as principal. Shipping can then decide for itself whether to issue the LOIs in the face of the request from Ambrose. That's where it originates from. They're the receivers who want the cargo off the vessel. They make the request to shipping to issue the LOI. It doesn't come from my clients. Exporters don't say, please issue a LOI. It comes from the receivers. I'll explain in due course why there was a process whereby shipping asked for approval from forests. But that approval, as clear from the argument that was accepted, that approval was not for the purpose of giving authority. That approval was for the purpose of ensuring that exporters' security for the price of the logs was not lost before an LC was in place. That was the interest that forests had. And that's the submission that the learned judge accepted in paragraph 63, and obviously I'll come on to explain that in due course. Anyway, so on ground two, the first question that arises was shipping acting as principals? And if they were, as we submit they were, and indeed we have the better of argument that they were, no question as to the scope of authority arises. It's only if you were to be against me on that, or satisfied that there was a good arguable case that shipping were acting as an agent for us as an undisclosed principal when issuing the LOIs, does the question of the scope of authority arise? And that's when we need to look at the HAU point, and it's in that context. And on that we say, it's too late to run the point, but in any event, if it were to matter, it's clearly misconceived in the context of seeking to apply it to the undisclosed principal doctrine. And I can make that good in a variety of ways. Most obviously, when you start to even begin to unpick it and analyse it, you'll see that what it requires is for some form of estoppel to operate against my clients. And no doubt you'll have in mind the fact that, as Lord Sumption made perfectly clear in the Playboy case, the doctrine of undisclosed principle is a mutual one. If it applies, it means the undisclosed principle can sue on the contract as well as be sued. And if this principle of estoppel were to be applicable based on ostensible authority, it would mean that essentially a so-called principal who didn't give actual authority in truth to the sub-agent or the agent could nonetheless set up an estoppel against himself as a basis for suing on a contract to which he's not, on the face of it, a party. And we know, I mean, my learned friend says, well, it's a point of universal application in the context of agency, this AJU point. We know that, well, not only is the doctrine of undisclosed principle anomalous in itself, but we know that other fundamental principles don't apply to it, the most significant of which is the doctrine of ratification. Now, the doctrine of ratification is a way in which actual authority can be given retrospectively to an agent or someone purporting to act on the principal's behalf. But that doctrine does not apply, and there's House of Lords authority for this, does not apply to the doctrine of undisclosed principle. And that's because an undisclosed principle cannot ratify the act of an agent, even if the agent is purporting to do it on the principal's behalf, and even if the principal agrees, as happened in that particular case after the event, to participate in the contract. He cannot ratify it. And we would submit, and I'll demonstrate why tomorrow probably, that the reasoning, the rationale for that rule set out in the House of Lords decision is exactly why the idea of an estoppel arising in circumstances where the so-called sub-agent relied upon a representation made by the principal as to a holding out by the middle agent, who then gave a false but within his ostensible authority representation of authority, somehow enables that principal then to jump over that hedge and sue a third party on a contract is, in my submission, it's well, not only is it a novel proposition, but it's simply misconceived. It's not a Supreme Court point. As my own friend fairly answered to my Lord Justice Zacaroli, HAU is not a undisclosed principle case. It's never been applied in in an undisclosed principle context. And when we look at it again, paragraph 5-015 as to the rationale behind the rule, one can see quite clearly from what Bowser says at least, the rationale is to save the agent from being in breach of warranty or authority, and to save the contract. Now, none of that applies. That rationale simply does not apply in the context of the undisclosed principle doctrine. The reason it doesn't apply is because the agent is liable on the contract in any event on its own account. Sorry, I'm actually I've gone rather more into the argument than I intended at this stage, but it seemed to me that it's moderately interesting, and I will come back to it, although without repeating what I've said. But what I do want to do today, is to deal with the contractual scheme, because my respect for submission it is fundamental, and obviously we'll look at what the contractual scheme is, but in light of what my own friend said today, in my respect for submission, there is no credible basis in the evidence for any suggestion that the express contractual arrangements here were varied in some way. That's, when we talk about McCorberism, that's not McCorberism, it's actually wishful thinking. There is simply no credible basis for saying this case should proceed, because you can't trust the contractual scheme as being a representation of the agreements that were made between the parties. That's my submission, just unrealistic in the context of this appeal. And now, one of the three key documents that we need to consider, the first of which is the letter, and I take them in chronological order. The letter dated the 30th of November, which is at Supplemental Bundle 1, at page 177. And you looked at this already, but there are a number of features. I mean, it's a very important document. What this document is, it's Forrest telling its clients, obviously this one is to Tiaki, but it was copies to all my clients. It's explaining to them what the role and purpose of shipping will be within the business operations that related to the export of logs. And part of improving the service was the incorporation of TPT, and from time to time TPT shipping will charter ocean-going vessels suitable for log shipment. Now, there's every indication there, particularly the juxtaposition as to how TPT forests are described in the next sentence, open brackets, acting as your agent, the TPT shipping is then going to be acting as principal charterer. And that's why, because TPT shipping is the charterer, that's why forests will enter into agreements with shipping for the shipment of logs. That presupposes that shipping is not acting as an agent, but actually is acting as a principal, and that forests will be making agreements with shipping. And then the key, I mean, you've seen this already, but the key sentence is the first sentence of the next paragraph. TPT shipping operations will be kept separate to the operations of TPT forests to ensure that the risks inherent in chartering vessels are effectively ring-fenced. So this is a letter explaining to my clients that TPT will have within a fence built around it, the risks inherent in chartering vessels. And the reason that's being said to my clients is because that is one of the benefits that accrues to my clients as a result of shipping's introductions as a principal charterer in the business. And as this becomes crystal clear, so not just do we have the ring fencing, but it becomes crystal clear when we look at the last section of this letter across the page at 178. In fact, this point, the learned judge didn't apply as much weight to it as perhaps it deserved. But it's a point very much in my favour under the heading accounting. And the middle paragraph, as we do now, forests will recover certain costs in accordance with the log marketing sales agreement. The costs of shipping will be recovered in the same manner as they would be where forests engages an unrelated third party to ship the logs. So my clients will still remain responsible for the costs of shipping, i.e., what are the costs of shipping? They are the freight, plus the demurrage, less the dispatch. That's what my clients are liable for, contracting with the charterers for space on their vessel. The key point is the next paragraph. Any costs, losses. Now, what are the losses we're talking about? The losses are the losses that are inherent within the risks of chartering vessels, one of which, of course, is liability on an LOI if the reciprocal person like Ambrose goes insolvent. That's one of the losses that can be suffered or is inherent in the risk of chartering vessels. Any costs, losses, and expenses incurred or suffered by TPT shipping, which fall outside the contracted rates in the shipping contract, and we can look at what they are, between forests and shipping. And then it's in bold. It's not just, they've actually taken the trouble to type this out and then add bold letters to it. It's the only part of the actual text, other than the headings, where they've used bold language, will not be recoverable from you. This is where TPT shipping provides a protection for you as suppliers. Now, my lord, that, my respectful submission, that presupposes and makes explicit that there is no right of recourse. Going to be no right of recourse from shipping to my clients, which is, and that being the case, the idea of there being some kind of agency relationship between my clients and shipping, which by definition would create a right of recourse, would completely and utterly undermine and fatally destroy the whole objective of the arrangements that were being set up. And my lord...
What's in it for shipping? I mean, people don't normally put themselves forward as, in your words, a sacrificial lamb without having something for their benefit.
Well, my lord, what's in it for shipping? Shipping was set up by the existing TTP Forest, or TPT group, of which Forest was part, the sister company to Forest. And the rationale, my lord, which I think my submission is clear, is that the purpose of creating shipping was not to create a new form of revenue generation, although, as we'll see, they were able to make some money. That wasn't the rationale. The purpose was not, let's create a subsidiary and then we can charge extra money from the exporters by adding another corporate body into the chain. The purpose, and we would submit a legitimate one, was to ring fence the risks. I mean, look, it's no different to the. We see this. Well, one classic example, perhaps I can show it, is in Bundle Authorities tab A2, so it's Bundle 2, but, tab 38. And this is a court of appeal case, and there was related companies, and one of the questions is what was the nature of the relationship between the two companies? Were they in the form of agents for undisclosed principals? And the relevant paragraphs I want to show you in the judgment of Lord Justice David Richards, as he then was. Paragraph 24. The principal ground of DML's appeal is that the judge's conclusion is fatally undermined by the fundamental agreed purpose for the establishment of DML and DPSL before it, namely that DPL and the properties were to be insulated from claims by tenants and others arising out of the letting of the residential properties. And then there's an example of, them being stung in the past, which led to for that purpose as being the reason for creating the company. And the last part is the last two sentences, my submission are important. If an agency relationship existed, DPL and its properties were not protected from claims by tenants and others. An undisclosed principal is as vulnerable to claims by counterparties as a disclosed principal. Further, an agent is entitled to be indemnified by the principal, whether disclosed or undisclosed, against liabilities incurred in the course of agency. So looking at paragraph 24 and then comparing it with what my clients are told on page 178 of Supplemental Bundle 1, any costs, losses, expenses that fall outside the contracted rates will not be recoverable from you, and that shipping is going to be to bear the risks within a fence ringed around it. All those purposes which are expressed would be undermined. And as this judgment, it's obviously on its own facts, but you'll see from paragraph 35, that appeal succeeded. And the Court of Appeal held that the fact that the judge had imposed an agency relationship, paragraph 35, is wholly inconsistent with the express purpose of Andreas and the others in establishing the arrangements involving DML to conclude that DML was DPL's agent. It would, Mr. Houseman QC and Mr. Quirk permitted to defeat those arrangements and the intention of establishment and so on. And it's not at all uncommon in this context. The Magdalen Spirit case, very similar, factually, to this case. It's a jurisdictional dispute, and two companies with the Vitol Group, VSA and Morel, and the question was Morel chartering as principal or agent? And interestingly, we can look at it, but look, Mr. Justice Legacy then referred to the fact that the purpose of Morel's involvement was to ring fence. It's ironic, perhaps where they got the idea. It doesn't actually work with the timing, but to ring fence the risk in relation to chartering from other members of the Vitol Group. So it's not at all uncommon for this type of arrangement to exist. And the commercial suicide point, once you understand what the purpose of shipping's role is, commercial suicide point actually falls away completely. The whole purpose was, okay, you get your indemnity from Ambrose. So it's very unfortunate that Ambrose went insolvent. Had that not happened, shipping would have been protected. But the idea shipping can break the fence.
Well, the idea of being a sacrificial lamb is that you do commit a kind of suicide, but
right. Well, so I won't call it suicide. It's a beneficial sacrifice for the benefit of others.
Well, it is effectively saying that shipping is doing things that it definitely wouldn't have done if it was an independent entity, and maybe its directors were not quite as in recognition of their own duties as they should have been. That's what you're saying, because
criminals.
Shipping is putting itself in a position where it isn't commanding a reward for the risks it's taking.
Well,
I have to say, this is the first suggestion I've heard of this sacrificial lamb thing, and it seems to me that this is an allegation against directors of shipping who are acting in a criminal way.
Well,
and I'm not sure my learned friend should be allowed to say that when all the other parties have gone.
Well, certainly not.
I'm observing what is the financial position of shipping, as far as we can tell, is limited to benefiting from the sale of a small amount of extra space.
Yes, that is right, my lady. Shipping, I certainly could stance my own friends, but I'm not suggesting. I was using that in a conceptual sense to illustrate the submission, not in any attempt to make any aspersions about the conduct of the directors of shipping.
I think they ought to be notified if you're even going to make that submission under Rustenburg.
Well, I will consider it overnight. If appropriate to withdraw it, I will. But it doesn't on any view detract from what I'm saying about the purpose as communicated to my clients, which is that the purpose is to ring-fence the risks and that there will be no recourse to my clients in relation to any losses that shipping suffers. And that doesn't mean that shipping were behaving, or the directors behaving in some form of illegal endeavour, because shipping had the benefit of the LOI, the back-to-back LOI from Ambrose. They were the party making the request coming up the chain to deliver against without the bill of lading. They took that indemnity, and had it not been for Amrose's insolvency, shipping would not have suffered a loss. So there's nothing improper in what they did. From a commercial perspective, I'm not suggesting anything they did was improper. What I'm suggesting is that it was agreed, or the express purpose, was there'd be no recourse in the event of a loss against either Forest or my client's ship, the exporters. That's the only point I'm making.
So that explains the loss arising under the LOI.
Yeah.
This is more general, though. All cost losses, there'll be no right of recourse. What other protections were there for other such losses? Was there recourse against anybody else in relation to such losses?
Well, that's an all-embracing question. But let me I can give several examples, possibly by way of an answer. It's
very dangerous cargo.
Yeah, quite. The likely recourse would be under a bill of lading, possibly, or if a party were to commit a tort or cause a loss in that way, there would be a right of recourse against them. The point that's being made here, though, is that there's going to be no recourse against my clients, i.e. the people creating or looking after the forests in New Zealand, chopping down the logs, which is what they do. There's going to be no recourse against them from any losses that shipping, who are 2 corporate steps away, were to sustain. That's what all the letter is saying. Which in my submission is a very important part of the background, and makes it, well, it's important for this sense, it makes it highly unlikely that either my clients or Forests would either intend or consent to shipping acting as their agents. Because to do so would totally undermine the ring fencing and the no recourse provisions of that letter. Thirdly, obviously the letter is only between Forests and my clients, but it does form part, we would submit, of the relevant matrix or background, certainly to be taken into account when construing the marketing agreements between exporters and Forests. So it's against the background of that letter, which sets out the purpose behind which shipping were created. One looks at the express agreements themselves, the first of which, of course, is the marketing agreement, which my own friend took you to. I think he took one as an exemplar. very happy to do that. It saves time, and they're all materially identical. And my own friend took you, I believe, to the relevant terms. The key ones are in section 5 under shipping terms, 5.2.1c and 5.21f. And the judge addressed those clauses in paragraph 73.2 and 73.3 of his judgment, which is at tab 14 of the court bundle, at page 170. Where he says, in my judgment, forests and exporters were correct in saying that the LMSAAs envisaged a dichotomy between situations in which vessels were chartered in by forests acting as agent for the exporters under clause 5.2.1c, in which case exporters would be the charterers, and situations in which shipping made space available on board ships chartered in by them from third-party owners, a situation created for them under clause 5.2.1f. And he says, in the current case, it's clear, in my view, from the very fact that shipping were involved, this was a clause 5.2.1f.
Was there any dispute below that if it was a 5.21f case, shipping acted as principal?
Was it disputed below?
Yes. If you were in F, then shipping is acted as principal.
No, that's accepted. I mean,
yeah.
No?
Maybe below, but not by me.
Well, that's what I wanted to ask. I said below.
Yes, sorry.
There wasn't any debate about it in the judgment.
No, there's no debate about it because it presupposes, by contrast, that shipping are contracting with forests, not as agents, but shipping will have chartered the vessels. I mean, it actually says that. From time to time, TPT, that's forests on our behalf, may have access to vessels chartered by TPT shipping. Well, in my respectful submission, 5.2.1f proceeds on the basis explicitly that TPT shipping will be acting as principals when they charter the vessels. That was certainly not contested below, which is why there was the argument about the difference. That's why it was such an important part of the debate. Which of the two clauses did the part, or which two clauses apply, and what the difference was. Anyway, what the judge found, and it's implicit if not explicit, is that if it's a 5.2.1f case, that means, if not on a determined basis, but certainly it takes the matter a very long way, that shipping is acting as principal when they are chartering the vessel.
521F does contemplate that there will be agreement on the terms of the shipment.
Yes.
Is that? I mean, where do we
find that?
Where do we find that there was some agreement? And
yeah.
What were the terms?
Well, we'll look at the flow of money and what the agreements were. There were two basic agreements in relation to money. One was the marketing agreement itself, which provided that my clients be liable for the shipping costs. And likewise, when you look at the agreement between shipping and forests, there was an agreement there that my clients be liable up the chain to shipping for the shipment costs. And what we say the shipment costs are, as is demonstrated by the wash-up procedure, is freight plus demurrage less dispatch.
Sorry, just obviously we're looking at the LMS.
Yeah.
And the question relates to acceptance by manager of offers. I don't think we've been pointed to any specific evidence other than wash-ups, which are inevitably post facto.
Yes. Well, you're right, my lady. There is the evidence is that shipping effectively dealt with forests pursuant to the SAA agreement. And if you would want to see any documentary evidence in relation to the prices that were agreed, you see it in the bill of lading, where you see freight payable as per charter party.
But do we have evidence of that sort of thing being passed by the manager? or not? Because this is talking about dealings between Forest and the manager.
I don't think that, I expect there isn't a particular email every time a cargo is shipped on board a vessel from chartered by shipping. It's right to say there isn't an email every time from Forest saying, this is the rate, it's the same as yesterday's or the day before, please agree it. That didn't happen. But the evidence we would submit, and you have to, one is, we are dealing at an interlocutory level, I accept that. But the idea that 52C 1F didn't apply because there isn't such a chain of emails between the manager and Forest every time the vessel, shipping a chartered vessel means that it's a C case. It is uncommercial in my respectful submission and unreal.
Well, I mean, at the very least, the manager must have known which vessels were going when and got the logs to the port.
Well, that was the only responsibility the managers have of getting the logs to the port. That's right. They didn't know, as Mr. Ellam said, they didn't know. They didn't know very much at all. They were mainly dealing with forests and logs, and they didn't actually know much about the shipping process, it's fair to say. But no, they didn't know. And in fact, as we'll come on to see, neither did shipping know. Shipping got a sort of outline schedule. It's one of the few documents my own friends didn't take you to. Perhaps when we look at it, we'll see why. Because it gives very little information. It's just very high level. The reality is that shipping was chartering, and we can see this from, perhaps I can show you this. Shipping was chartering 2 or 3 vessels a week. I mean, you can see that from page 280. I think it is a bundle, tab 40 of supplemental bundle 2. Tab 40, my lord. We didn't look at this document this morning. It's from Shipping's website. But as you can see, our scale and volume allows us to negotiate shipping rates for clients and customers. And over the page at 280, we're constantly in the shipping market, on average chartering a ship every 2 or 3 days. And that's repeated on page 281. On average, we charter a vessel every 2 or 3 days. And if you, I think one of your friends did show you the table, the same bundle, tab 56, on page 352. And in particular, this is the number of fixtures that TPTS were involved in, and the number on which my clients' logs were carried. And as you can see, for 2019, this is the table under paragraph 7, the total number of fixtures was 189 for the year. That's between 3 and 4 fixtures a week, which means TPTS is actually chartering a vessel virtually every day. But importantly, my clients' logs aren't carried on all of those. My clients' logs are only carried on 132. It has 57 charter parties. We don't know which ones, whether in the same week or otherwise. 57 charter parties shipping entered into, didn't even have my clients' logs on at all. And that's going to be important when we look at the timing point, but it's also important answering the question my lady puts, which is, could it not be a 5.2.1c case? In my respectful submission, it can't be, not just because of the obvious answer that forests are the only party who's envisaged to be the charterer, and they weren't, but because shipping was chartering more than simply vessels on behalf of, or for the carriage of logs belonging to my clients. I mean, there are only 2 possibilities identified in the express scheme, and 5.2.1c expressly envisages that forests will be the charterer, and the learned judge below found that the forests were not the charterer, either as a principal or as an undisclosed principal to these charter parties. And there's no appeal from that finding. And that, in my respect, submission is conclusive as to the 5.2 1 and 5.2.
Is that right? Is that right about your point on C? Is that it can't be a C case because C requires the charter to be with forests.
Yes.
But this is an agency agreement between the exporters and forests. So when it says the charter with forests, doesn't that envisage that it's forest as agent for the exporters?
Beg your pardon.
So I understand your point to be this can't be a C case because C requires the charter to be with forests.
It requires forests to charter the vessel, yes.
But does that prevent forests chartering the vessel as agent for the exporters? This whole agreement is about forests acting as agent.
Indeed, my lord. It does, because that would render it's the contrast between F and C that affords the answer to that question. Because when it comes to shipping, it's suggesting that shipping is the charterer and the forest is contracting with shipping, not contracting as charterer through shipping.
No, I see that. That's F.
Yes.
Your point is it cannot be C because C requires forests to be the charterer. And my question is, well, can't that envisage under this agreement forests being the charterer in its capacity as agent for the exporters, i.e. not as a principal?
Well, is my lord reading the last 4 words of 5.2.1c?
Yes, that's what I'm looking at.
My lord, 5.2.1c is envisaging, and certainly this was the understanding below, and what the judge found, is that the ship charter shall be between TPT and the shipping company on behalf of Tuamata, which suggested that TPT had to be a party to that charter. And what the learned judge has found here below is that, in fact, TPT was not a party to the charters, either as a, certainly didn't sign them, shipping did, and it wasn't an undisclosed principal. And that's why it can't be the 5.21c case in my respectful submission. And that's all consistent, we would submit, with the underlying commercial purpose behind which shipping was incorporated. It's also important when you look at this marketing agreement that there's no power to delegate here. There's no power to subcontract. In fact, there is a power to subcontract. Sorry, there is, but it's expressly subject to having taken permission from the exporters, and there's no suggestion that occurred. And it's not an all-embracing provision of authority. The paragraph 1.7, page 6, expressly acknowledges that no power to enter into any agreement or bind Tuamata in any way without the prior written approval of the manager, without authority under the express provisions of this agreement. So it's not a general power, it's only the specific power that's afforded by the agreements themselves.
Sorry, where's the subcontracting?
Sorry, the subcontract, yes, sorry, my lady. That is page 15, I think. Sorry, it's paragraph, page 15 of the supplemental bundle, tab 1, and under the heading assignment of rights.
Okay.
Yes, neither party shall, and then it's little 16.1.2, subcontract any duty or obligation under this agreement. Certainly there's nothing envisaged within the agreement that Forest is going to start setting up sub-agents to whom it's going to be able to delegate authority. And that brings me on to the so-called SSA. And my little friend made something of a forensic point, perhaps, but made something of the fact it's described as an agency agreement, as if that means anything that moves the ball. But I've no difficulty with being described as an agency agreement if it's reflecting the fact that Forest is the agent. Because when we look at it, the only party described as an agent within that agreement is forests. That agreement is in Supplemental Bundle 1 at tab 4, page 68. Now, at the end of the day, this is essentially a question of construction. It's a relatively short point. But what I would respectfully submit is that when it's construed and understood against the background of the letter sent to my clients by Forests, which sets out what their express purpose for incorporating shipping was, and it's construed against the background of the marketing agreements as well, when it says in the introduction under domain for lettered recitals, if you like, what the nature of the business is, it's providing that TPT shipping is in the business of providing shipping services using charter vessels and independent carriers. And TPT shipping has agreed to provide shipping services to the export clients. This is my respectful submission. This is language consistent with TPT shipping acting as principal and contracting through Forests, who are the agents, provide services via principal to my clients. And that, we would submit, is clear from the entire scheme and the terms of this agreement. The only wrinkle being paragraph 5.1, which is basically the high watermark, if I'm certainly listening to my own friend's oral submissions, the high watermark of my own friend's case is the fact that 5.1 contains within it the words and on behalf of, as well as for. Now, in my respectful submission, there are three key points to make about those words. The first is this, that the words for and on behalf of do not have a fixed meaning. They are not a term of art. The second point is that the phrase has, or is capable of bearing a wide range of meanings from the narrow principle of a pure agency arrangement, one end, or at the other end of the spectrum, the concept of for the benefit of. And in particular, the meaning of the phrase will be, or rather the phrase will take its meaning in any particular case from the overall context within it which it is used. So those are my submissions on how you should approach the meaning of that phrase. We have enough authorities already, but there is an authority from which I've derived those propositions if it matters. I think it's called Rochdale and Dixon from 2011, called Peel Case. And what Lord Justice Rick says, I'll have a look at it overnight and give a copy to my own friend, and if it assists, I can provide it to your lordships tomorrow. But those are my submissions on what that phrase means, and what you need to do is construe the agreement as a whole. You construe it against the relevant background, which includes the contracts. And in my respectful submission, the idea that this agreement effectively appoints shipping as a sub-agent of forests for the purpose of binding exporters to contracts with third parties and thereby interfering with exporters' rights is simply implausible. It's the language and the form of contract whereby shipping is contracting as principal, providing services to my clients, not acting as their sub-agents in obtaining those services from other parties.
Does the term services include the provision of letters of indemnity? Mr. Berry submitted that it does.
Well, it doesn't expressly do so.
Well, it depends on whether it's a service for the handling and shipment of the products up to the agreed point of delivery, I suppose.
My lord, my respectful submission with this, no, it doesn't. And the reason for that is because what TPT shipping are agreeing to do is charter the vessel, make space available, pursue a disagreement with Forest to my clients. And in return for that, my clients are obliged to pay the freight, the demurrage, and we pay the net shipping costs. So dispatch is credited, which effectively is a saving on freight because you paid for your lay time. Anyway, we pay the net shipping costs. That's our obligation. The question of an LOI, the charter party doesn't entitle anybody to require the charterer, i.e. the person providing the shipping services, to issue a LOI. It's a matter for the charterers. And that's why once you get to the end of round one of the appeal, and if as we submit you should not interfere with the learned judge's decision, that there's no good arguable case that shipping contracted other than as principal under the charter party, that ultimately we would submit virtually provides the clear answer to the second ground of appeal, because it'd be absolutely remarkable if shipping, having contracted as charterer in its own right, should suddenly be contracting as in some other capacity, despite what the charter party says, when issuing an LOI. It's an option that the charterer has, and when we look at the approvals, the approval process was not one whereby shipping were saying to Forests, please can I have authority to issue an LOI? They were saying, we're basically saying, we're going to issue an LOI, is that okay by you? It's no different to my gardening contractor saying, I'm going to order a load of soil, it's going to cost X amount of money, are you okay with that? And if I say yes, it doesn't mean that I'm going to be an undisclosed principal to the contract that my gardener makes with whoever supplies him with his soil. I mean, I'm an example. But what we're showing you tomorrow, my lord, is this, that at paragraph 63 of the judgment, what the learned judge did was accept a submission by Mr. Rainey. When you look at the exchanges that took place between Forest and shipping, what is happening is that what the concern is the risk that without a letter of credit, clean letter of credit in place, by discharging the goods, that security for the price would be lost. And that's an interest that Forests have because they are the beneficiaries of the letter of credit. That's why they were being asked, is it okay to issue the LOI? Because it's implicit in doing so that the goods would be discharged without proper documentation, in which case potential security could be lost. That was the reason. They weren't asking, please can we have authority to issue LOIs on behalf of exporters as their undisclosed principal. It was simply inconceivable if, as I submit is the case, they were the charterer under the and contracted as charterer as principal. The other point when you look at the construction of the so-called the SAA agreement concluded in 2012 is that if you look, it's clear that throughout Forest is being described as the agent of exporters. And it's distinctly notable that there's no suggestion in any sense that shipping is to be characterised as a sub-agent. In fact, the fact that the concept of agency is used exclusively to refer to Forest and not shipping is, in my respectful submission, highly indicative of what the agreement constitutes. Ultimately, my respectful submission, what the agreement amounts to is this. When construed as a whole and in context and against the background of the marketing agreements, the SSA amounts to no more than a conventional relationship between a cargo agent, namely Forests, and a marine service provider, namely shipping, who acts effectively as a groupage carrier or as a principal contractor, providing space for my client's logs, and others, of course, for my client's logs on its chartered tonnage. So those are they're the express contractual arrangements that were entered into here, along with, of course, the contracts themselves. And the contracts themselves, as you've seen, have shipping's name on them and no agency is disclosed. And that in itself, we would submit, creates a strong presumption. This is the point that Mr. Justice Leggett made in the Megaland Spirit, strong presumption that they contracted as principals. Of course, it's capable of being the doctrine that undisclosed principle means it's capable of being shown that somebody else is, in fact, the principal. But that requires, according to Mr. Justice Leggett, convincing proof. And my submission, there isn't such convincing proof. But moreover, for the purpose of this appeal, my respectful submission, the learned judge's evaluation of the evidence that led him to the conclusion that my clients had the better of the argument, that shipping contracted as charterers in their own right, was one perfectly within the scope of his ability in terms of his evaluation of the evidence, is not flawed in any material way. There's no error of law here, as my friend suggests there is in the context of the agency point, the LOI AGJU point. On ground one, there's no error of law, simply a question of evaluation of the evidence as a whole, and in my respectful submission, the conclusion that the contractual scheme supported and provided the answer effectively, that shipping were contracting as principal as the face of the contract suggested, was plainly, in my submission, right. Now, there are obviously other considerations the learned judge took into account. It's 10 past. I'm happy to do one more if I'm able to.
Well, we normally finish about 15:15. If you could do something useful within that time, do. I'm sure all your submissions are useful, obviously. But if you have a discrete point that you can make, then do.
Well, my Lord, let me try and deal with the timing point. I've already alluded to this, and it's a further point, and it's a point in my favour, and it's this. We've already seen that shipping. I suppose the point my own friends say, there's nothing to justify the judge is finding that shipping didn't know whose logs were going to be on board the vessels. That was the point he made. And there is plenty of evidence, not just the fact that the contracts of sale were only concluded 6 or 7 weeks afterwards. That's obviously an important point, but it's not just that. What we know is that shipping schedules themselves were not precise. They were general. And secondly, shipping was chartering 2 or 3 vessels a week. So the 2 or 3 vessels a week it chartered in September of 2019, the idea it knew that on the 5th of November, precisely whose logs were going to be loaded on board the vessel is simply unreal. And the judge was perfectly entitled to infer from all the evidence that they didn't know exactly whose cargo would be shipped on board the vessel.
I would almost think there'd be hardly any logs left in New Zealand by now.
And my Lord, there is one further point on this, which is, my respect for submission, very telling, which my own friends passed over, which is the terms of the charter specifically permit cargo to be discharged at one safe berth, one safe port, either in China or in India. Now, that in itself, in my respectful submission, is a further indication that things were uncertain at the time of chartering, and taken all of those underlying evidential considerations together, the judge's conclusion that the timing or the gap between the shipment of the goods and the conclusion of the charter parties was consistent with shipping acting as charterer in its own right as principal was entirely fair and justified, and an accurate or a finding that doesn't reveal any flaw which would justify a legitimate criticism of the judge on that point.
Should we be looking at the shipping schedule?
We can look at one.
You said something about
Yes.
that earlier.
I did show you it. You're right. We have one, I think, at it's tab 18 of bundle or supplemental bundle 1. Page 195. The shipping schedule appears page 195, top heading. I mean, my respectful submission, the suggestion that the shipping schedule contains sufficient information, which it is, to enable shipping to know, weeks beforehand whose cargo is going to be loaded on board is one particular vessel is simply unreal. And the reason this is so important is because, as I said earlier, the doctrine of undisclosed principle, there's no scope for the concept of ratification. So there's no prospect of shipping simply chartering vessels in the expectation, hope, or even the belief that these particular exporters will have their cargo shipped on board that vessel. That doesn't work, because what the House of Lords said about why you can't have private thoughts of agents enabling principals to jump on the bandwagon after the event.
Do each of the exporters ship from a variety of load ports, or is one exporter exclusively for one port and another exclusively for a second port?
I have to say I don't know the answer.
Because if the latter, then this would tell you which exporters are going to be involved, because it tells you the.
Can you explain that to me, Mark? Because I haven't understood that for you.
Yes, if you've got the schedule at 195, if all of the Tuamata cargo goes through a port called MAP, and neither of the other shippers, exporters, uses that port, then that will tell you that the cargo for the Jasmine is a Tuamata cargo.
Well, there might be an additional question, given we've been told that not all the charters were for these three
Yes, that's true.
exporters.
Why?
Yes, it won't tell you about the odds and ends.
Right. I mean, one point I'd make, my lord, is this: that this is 11th of October. The charter party we're concerned with is one that was concluded on the 25th of September, and it provided for loading in December. This doesn't even go beyond the 7th of November. The idea that anyway, I think my lord makes a fair question. I don't know the answer to it now. I'll see if I can find out the answer by 10:30 tomorrow morning.
All right, very good. We'll think of something else overnight.
Yeah.
10:30 tomorrow then. Thank you all.